Distinguished delegates and observers, it gives me great pleasure to address this Commission at the opening of its 55th session. If travel restrictions and hybrid modalities prevented me from addressing you in person in Vienna at the last session, my participation at the United Nations Ocean Conference in Lisbon means that I am again addressing you remotely. So once again, I find myself on the opposite side of the Atlantic Ocean, one that I am pleased to say continues to serve as a vital trade corridor above the waves, as well as a focal point for international cooperation towards sustainable development below the waves. I'm also pleased to welcome you back to the United Nations headquarters. This welcome is all the warmer at this 55th session marks your return to full in-person proceedings since 2020. I know that many of you have been yearning to return, not only to see familiar faces, but also to make use of the ancestral consultation break to discuss and progress the work before you. As you know, the United Nations headquarters is home to the Office of Legal Affairs. While the International Trade Law Division has been based in Vienna since 1979, the rest of the Office of Legal Affairs is based here in New York. In addition to the Office of the Legal Counsel and General Legal Division, the Office of Legal Affairs includes the Codification Division, the Treaty Section, and the Division for Ocean Affairs and the Law of the Sea. I mentioned in my address to the Commission last year that the Office of Legal Affairs celebrated its Diamond Jubilee in 2021, having been established in 1946 as the legal department in the United Nations Secretariat. Let me now take this opportunity to provide you with a brief snapshot of the recent achievements of these parts of the Office of Legal Affairs. To begin with, the Codification Division services the Sixth Committee of the General Assembly and the International Law Commission. For the Sixth Committee, the division works closely with the International Trade Law Division colleagues to support the timely consideration of this Commission's work, including the legislative texts put forward for adoption by the General Assembly. As you know, the International Law Commission is the other legislative body established by the General Assembly. One notable recent achievement of the International Law Commission is the adoption of a guide to the provisional application of treaties. As it happens, a question linked to the topic was considered only this year by Ancestral Working Group 6 in developing the draft convention on the judicial sale of ships when it evaluated options for making the repository mechanism available to states after they have ratified the treaty, but before the convention has entered into force for them. Next is the treaty section of the Office of Legal Affairs, which contributes to ensuring transparency of the international treaty framework, wider knowledge of the law of treaties, and broader participation in multilateral treaties deposited with the Secretary General. Since 1945, more than 75,000 treaties have been registered with the Secretariat pursuant to Article 102 of the UN Charter. And this responsibility falls to the treaty section, which is also responsible for analyzing and publishing those treaties in the United Nations Treaty Series. Thanks to a new regime adopted by the General Assembly last year, this will now be done in a way that aligns with latest practices and technologies in information management and further strengthens multilingualism. The treaty section is also responsible for discharging the Secretary General's depository functions under multilateral treaties, including conventions approved by UNCITRAL. Prior to approval, the treaty section works closely with the International Trade Law Division colleagues to review and comment on the final clauses of draft UNCITRAL conventions and to consult on depository functions. After approval and adoption by the General Assembly, the treaty section participates in the signing ceremony to receive signatures and later liaises with states to receive instruments and notifications relating to the Convention at the United Nations headquarters. Finally, for its part, the Division for Ocean Affairs and the Law of the Sea, commonly known by its acronym DAWALOS, is responsible for promoting wider appreciation of the United Nations Convention on the Law of the Sea, UNCLOS, and its uniform and consistent application and implementation. Now, this year is an important year for oceans and has been particularly demanding for DAWALOS. To begin with, it was responsible for servicing the fourth session of the Intergovernmental Conference on an International Legally Binding Instrument under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, also known as the BBNJ Conference. And this was held from the 7th to the 18th March this year, after having twice been postponed owing to the COVID-19 pandemic. In addition, DAWALOS has been actively involved in preparations for the 2022 Ocean Conference, which provides historic opportunity for states and other stakeholders to come together to begin a new chapter in global ocean action and to propel much-needed science-based innovative solutions to sustainably manage our oceans into the future. The active role played by DAWALOS provides an opportunity for the Office of Legal Affairs to emphasize how the conservation and sustainable use of oceans and their resources can be enhanced by implementing international law as reflected in UNCLOS. Ladies and gentlemen, the full program for this 55th session is testament to the productivity of the Commission and its working groups over the past year. Despite a global pandemic, the special arrangements that the Commission has put in place have allowed barriers to in-person meetings to be overcome and work on two legislative texts, not least one treaty and one model law, to be completed and presented for approval at this session. These arrangements have also allowed preparatory work to advance on new topics, such that a number of them will soon be eligible for assignment to a working group. Allow me now to conclude by offering some reflections on the two legislative texts that you have before you and some other highlights of the agenda for this session. Within its sphere of application, the harmonized regime established by the Draft Convention on the Judicial Sale of Ships is significant given the crucial role of shipping in international trade and transportation and the high economic value of ships. Adequate legal certainty and protection for purchasers can positively impact the price realized by a judicial sale to the benefit of both ship owners and creditors, provided that adequate safeguards are implemented and enforced in the conduct of the sale. The Convention complements other international efforts to harmonize private law aspects of maritime law within the international law framework reflected in UNCLOS, including its provisions relating to the nationality and status of ships. It also promotes institutional cooperation with the International Maritime Organization, which will assume the role of repository under the Convention. At a time when multilateralism and the international rules-based order are under strain, the preparation of the Draft Convention provides an example of multilateralism at work. What is more, it provides an example of multilateralism at work despite a global pandemic. And of the 6 sessions of Working Group 6, during which the Convention was prepared, 4 took place in hybrid format, with most delegations participating remotely. And this is testament to the commitment of states and international organizations to the project as well as the agility of the Secretariat through the International Trade Law Division in supporting the linear progress of negotiations. The draft model on the use and cross-border recognition of identity management and trust services highlights the importance of identity and authentication in the digital age. It also provides an opportunity to validate the principles and approaches that UNCITRAL has applied in this space for several decades now. The Office of Legal Affairs is also following with a particular interest the ongoing exploratory and preparatory work being carried out on legal issues related to the digital economy. After all, the legal characterization and assessment of emerging technologies and their applications is equally relevant to the operations of the United Nations as an organization, including in the implementation of the Secretary-General's data strategy. In addition to these legislative texts, the Commission also has before it draft recommendations to mediation centers on the use of UNCITRAL mediation rules. And last year, this Commission completed its work on a legal framework for mediation by approving the mediation rules, complementing the Singapore Mediation Convention and Model Law on Mediation that the Commission had finalized in 2018. Now, the complete package of texts showcases the diversity of the UNCITRAL toolkit in progressively harmonizing the law in this important and growing area of international trade. After finalizing its work on these three topics, the Commission will consider a range of important and topical areas of possible future work against the background of its current legislative and non-legislative activities. So with that, I have the pleasure of declaring the 55th session open, and I wish you the best of success in your deliberations. Thank you.